Oh, okay. The presumption is that you've seen the full page ad and you were directed to the YouTube site that where you're now seeing this video. So what we're focusing in on is the certificate of vacation that is in these full page ads, and that's the whole crux of what we're doing here. We're trying to get the courts to uphold the act of Congress. Now, it might be, what you would think the courts would uphold the act of Congress. We got this presidential election going on. Hey, Trump, let's return America to the glory it was. Well, what kind of glory if you can't uphold your own laws? I mean, this law was signed by the President of the United States. It's a federal act. It was voted on by all the senators, all the congressmen, okay, that were elected by the people. And what this act says, that if you get this certificate of vacation of conviction, which I have, it's there's my name. We're going to zero in on it. Albert Thrower. This is certified Albert Thrower. Blah blah. Signed by federal judge Sam Bell out of Akron, Ohio. Certificate of vacation of conviction. Now the Supreme Court right here in Tudum says, Tudum versus United States, there's the site if you want to check it, is that this section 5021 of the United States Code enables an eligible youth offender to re-enter society and conduct his life free from the disabilities that accompany a criminal conviction. So what it is, it's stronger than a presidential pardon. You're allowed to testify under oath. You've never been convicted before. You're allowed to buy firearms and fill out on the form, are you a convicted felon? No. Okay, and you are telling the truth. That's the case on Fryer. Now Fryer, United States versus Fryer, he was convicted, but he pled guilty, and then it became apparent he had one of these certificates of vacation on the prior conviction. And it says, once conviction had been set aside pursuant to the provisions of the Youth Corrections Act, it is expunged from defendant's record, and for all purposes, it may not later be used to convict a defendant of violating a statute which requires as essential element of the offense a prior felony conviction. So what happens is when I'm arrested, there's a gun in my office. So they say, well, we're going to charge you a weapon under disability. Well, it turns out that I had this certificate. Now, I showed it to the lawyer George Emershaw, but Mr. Know-It-All, he don't research the law, anything. But had he researched it, the law was clear at the time that I was not a convicted felon and I could not be charged with a weapon under disability. So the lawyer goes in and pleads to the charge. I'm supposed to plead to it, but he pleads to it. So now all I'm trying to do is void out this charge, because the law says that I was not a convicted felon. Every time this comes up in the United States, it turns out, oh yeah, I had the certificate of vacation, they void it out. They say state law, when it comes up against federal law pursuant to the Supremacy Clause, that it cannot conflict with the federal law. The federal law is supreme. Now, for 12 years, I went through all the courts, and everybody wants to ignore it, except for this, the Sixth Circuit. They said that they acknowledged, the Federal Youth Corrections Act, and they said that I had relief coming. Well, the relief is to void out this package plea deal because of this weapon under disability that, as a matter of law, I'm innocent of. Like the Supreme Court says, if the prosecutor and the defense attorney and the judge, if nobody understands the law, how can the defendant understand the law? So this stuff's void, okay? It's the state even admitted, like, oh, he does not have a weapon under disability. You know, he's innocent of it, but they don't want to give effect to it. Okay, let's go down in court in Summit County and void this out. We're gonna void this weapon under disability out. Okay, like George Emerson said, oh, you're dead in the water on the weapons charge. Well, no, you're dead in the water on the weapons charge, because I'm actually innocent. As a matter of law, the Supreme Court of the United States, every court in America that has looked at this would void this out, except for these petty people down in Summit County. Well, we aren't going to uphold the law. Well, you say Summit County, but I took it all the way up to the Sixth Circuit. You know, politics. Hey, let's talk to this guy. Let's talk to this guy. So we're not going to uphold the law. We're not going to uphold the act of Congress. F the act of Congress. The act of Congress doesn't exist. He's nuts. Okay, he doesn't know. They think it's too complicated, that nobody can figure it out but them. But the law is clear. Now, if you want to email me, I got an email here. It's my name. It's athrower1234@gmail.com. This is my first initial, athrower1234@gmail.com. And it'll flip up a picture of this certificate of vacation in the corner, so you know you're at the right site. So that's why it's unfortunate that we got to take this to the people, because you would think that the judges, that they would do the right thing, but they're so instead we got to take it to the people. Okay, so I'd like to hear back from you if you have any input on this. Oh, see right here, relied upon the supremacy clause of the federal law. It is the opinion of this holding when the federal law is involved. Regardless of how compelling this argument may be, when the expunction is we'll just scan over this. Here it is. District Judge Don Young, and then that's out of Toledo, Ohio. It went up to the Supreme Court and quoted in Tudum that once a conviction had been set aside pursuant to the Youth Corrections Act, it is expunged from the defendant's record for all purposes. It may not be later used to convict defendant of violating a statute requires as an essential element of the offense a prior felony conviction. Sentence vacated and defendant discharged. That's what we want. We want this. You give effect. You void out the weapons charge. Because had we gone to trial, they would have had to prove that I was a convicted felon. But pursuant to the Federal Youth Corrections Act, I was not. So as a matter of law, they could not have proven this. So it doesn't matter if you plead guilty, because you can't plead guilty like that's what Fryer did. He pled guilty, and the federal judge says it doesn't matter if he thought he was a convicted felon. The fact is that legally he was not. One cannot know what is not so. So in this turbulent age, where going over blowing up terrorists with drones and all that, like what they justify as, well, it's our way of life or theirs. And so our way of life is upholding our own laws for all the people. That's what the Constitution says. Not just for the people that got money, not for the people that stole money, not the people, that is all the people. Thank you.